Is it back on?
Yes, sir.
Excellent, thank you. Mr. Melnick?
Judge, I think we clarified Mr. Carr's questions. He thought that he was only entering a plea to one count of, on the 19 case, to one of the counts of entering auto. But I've explained to him that that's not, the state is not offering him that. So he would like to enter the plea under Alford versus North Carolina on the 19 case. The 20 case is not an Alford plea.
Okay, and I'll hear from Ms. Hall at the appropriate time. She's opposing that, but I'll hear from her and figure out how I'm gonna manage that. You remember where you left off, Ms. Hall?
I do, Your Honor. I'm sorry, can I just clarify? He said the 19 case Alfred, right?
Correct.
Okay. Thank you. So let's start with that. Mr. Carr, is it your decision to waive these rights and enter a guilty? I'm sorry, let's start with the 19 SC 168896. Are you pleading guilty because you have decided it is in your best interest to do so?
Yes, ma'am.
Are you aware that even if you do not admit guilt, this is a plea of guilt, this is a plea of guilty, I'm sorry, this is a guilty plea and places you in the same position as if you were convicted by a jury at trial?
Yes, ma'am.
For the indictment 19 SC 168896, how do you plead to the charges of 4 counts of entering an automobile? I'm sorry, 2 counts of theft by taking felony and 3 counts of theft by taking misdemeanor.
Guilty.
Is this guilty plea freely and voluntarily given with full knowledge of the charges against you?
Yes, ma'am.
Do you understand you have only a limited right to appeal this guilty plea conviction?
Yes, ma'am.
Do you understand that you only have 12 months from today for a misdemeanor charge and 4 years from today for a felony charge to file a habeas corpus petition challenging the voluntariness of this guilty plea?
Yes, ma'am.
Thank you. And as far as case 20 SC 175155, is it your decision to waive these rights and enter a guilty plea because you are in fact guilty?
Yes, ma'am.
How do you plead to the 1 count of entering an automobile?
Guilty.
Is this guilty plea freely and voluntarily given with full knowledge of the charge against you?
Yes, ma'am.
Do you understand that you only have a limited right to appeal this guilty plea conviction?
Yes, ma'am.
Do you understand that you only have 4 years from today for a felony charge to file a habeas corpus petition challenging the voluntariness of this guilty plea?
Yes, ma'am.
Thank you. Your Honor, the state is aware of 6 prior felony convictions by this defendant dating back to 2013, which was a possession of tools case at Fulton County. Following that case was a conviction in 2014 for a robbery. He did take that conviction on the first offender that was revoked. He also has an entering automobile case out of Fulton County, which is 14 SC 124163. This position dated February 17, 2014. An entering automobile out of Cobb County, this position dated April 12, 2017. And 2 additional cases out of Fulton County, one being the possession of a firearm by a convicted felon. This position dated October 1st, 2018. That is 16 SC 140997. And then an entering automobile case, 17 SC 148943. That disposition date is 10/1/2018. The only case that is still active is the 12 SC case, which is the robbery case. He has 1 year, 2 months, and 10 days remaining. Starting with the oldest case, Your Honor.
When you say the oldest case, by incident date or
Yes.
indictment date?
By incident date,
Okay.
which would be the 20 SC 175155. As this case proceeds to trial, the state would have proven that on April the 20th, 2016, and this would happen at 2 different locations. The first location being 1460 Northside Drive, that's in Fulton County, and the second location being 500 Bishop Street, which is in Atlanta, Georgia, also Fulton County. Officers went to the first location, 1460 Northside Drive, in reference to theft to an automobile. Met with two victims, Mr. Matthew and Mr. Frye, who let them know that their cars had been broken into and several items were taken out. Those cars were parked at a Goodwill parking lot. And then while the officer was investigating that automobile incident, he received another dispatch to the 500 Bishop Street, where there were 3 additional victims, Miss Rainey, R-A-I-N-E-Y, Dr. Miller, M-I-L-L-E-R, and Mrs. Ogletree, O-G-L-E-T-R-E-E. All 3 of their vehicles had been broken into at that incident. There was blood at that scene and 3 fingerprints. Nothing came back on the prints at that particular location, but there was a hit that came back. The CODIS hit came back this year to Mr. Dontavia's car on Miss Ogletree's vehicle. That is all we have on that case, Your Honor. That total restitution in that particular case was the $7,380.21. And then, Your Honor, on June 6th of 2019, officers were called out to Goodman's restaurant, which is located on, 777 Ponce de Leon Avenue, Atlanta, Georgia, in Fulton County. Officers went out to the location in reference to a break into a vehicle. When they arrived, there were 4 vehicles that were broken into, with 3 vehicles and 4 victims. That total restitution for that incident was $5,348.98. In that particular incident, Your Honor, there was a palm print that was left on one of the vehicles. That palm print was tested by APD. It came back to the defendant Dontavia's car. There was an offer made on both of these cases to Mr. Melton before we received additional evidence. That was a time when we thought we received everything from APD. So the offer of 531 for both cases was extended. Before the offer expired, we received additional information on the car that was used to break into the vehicles at that particular location. The license plate that my investigator ran came back to the address of Mr. Carr. Because the offer did not expire, we kept it, and that's why the offer expires today. Your Honor, we would have been asking for more time if that offer had expired before. That is all from stuff. And also, many of the victims are watching via YouTube, and I believe Ms. Rolek has one impact statement too.
Okay, I'll get to that in a second. I just want to work through a couple of things. So sticking with the case you were just talking about, the June 2019 at Dugan's. Until recently, the way the state would have connected Mr. Carr to the entering autos was a palm print and then video footage that would indicate the same person. You can't tell who the person is, but the same person is breaking into all the cars. And lo and behold, on one of the cars is Mr. Carr's palm print.
That's correct.
Fast forward, more recently, you've learned that you've obtained evidence that shows, I'll call it the getaway car, the car that this person who was breaking into the vehicles gets into or arrived in.
Was using during the internominals.
Meaning he was ramming the other cars?
No, he was driving to each car and he'd get out of that car, look into it. If there's something in the car, that's when he'll break the law. Then drive to another car in the same parking lot.
Okay.
And it was the 3 cars in that particular.
Okay, that car has registration that resolves to an address that belongs to Mr. Carr.
Yes, sir.
Okay, so it's a stronger case.
Yes.
You keep saying 3 cars. There are 4 counts of entering auto. Are there somehow 2? How is it?
That's my mistake. That's why I keep juggling. I'm sorry, Your Honor, because I'm getting the cases.
Yeah.
The case where we have 1 entered automobile, it should have been indicted with several entered automobile cases.
We'll get to that one in a minute.
So I'm crossing. I apologize. This Dugan's case has 4.
4 cars.
vehicles. Yes.
Okay, got it. The 20 SC case, which is this north side, Goodwill and then Bishop Street. Mr. Carr is pleading guilty to entering into Ms. Ogletree's Toyota Sequoia. So if there was something taken from Ms. Ogletree, he ought to be on the hook for restitution for that. You mentioned a bunch of other victims, all of whom may still be upset that their things were taken. I'm not sure what the theory of recovery would be for restitution to be paid to people for cars that aren't covered by vehicles that aren't covered by this indictment. So the 7,000 plus figure, if that is relating to items taken that were not inside the Toyota Sequoia, I hear from Mr. Melnick, but I don't know how I'd be authorized to order defendant Carr to pay restitution. He's not charged with, I'm not saying he didn't do these other things, and it may be a super strong case, but the only thing he's charged with is entering Ms. Ogletree's vehicle.
That's correct, Your Honor. This case was one of the last cases that was indicted before we went out for a pandemic. So I would re-indict this case if we have a grand jury and add those people. And I've spoken with Mr. Melnick about the restitution. If the defendant is not willing to, I know you're not authorized, but if he's not willing to also pay the restitution for those cases, then what I would need to do is re-indict it, because it's only fair to say received.
If both sides agree, meaning defense and state, I can have as a condition of probation, you're paying restitution of X dollars to person A, Y dollars to person B. You'll need to spell that out. I think we're going to table restitution for today. It sounded like Mr. Melnick might want to get a little more information, but that helps me understand it. It's sort of accepting the inevitable. Take the plea now rather than waiting until, I guess, you plead to an accusation if one were drawn up. But here we are today. Okay, that helps me. Ms. Rolak.
Good morning. This victim impact statement is from one of the victims from the 2016 case. His name is Mestophia Frame, Mestophia, Frame, Frame. Good morning, Judge McBurney. I shared with Ms. Rolak when we spoke my shock to be contacted about my loss some years ago. I'm feeling so many emotions at this time about the crime and the violation of my person and my personal property. Thankfully, at least one of the criminals is now going to be held accountable for their violations to myself and many others. I lost so much on that day from my personal and professional business. Personally, I lost invaluable family information, documents, photographs, and business. I have my 102-year-old grandmother to still question me about documents and photographs of her grand and great-grandparents that I have still yet to disclose to her that they were stolen. Really hurts. But I refuse to hurt her with that news. I am upset that my laptops were taken and probably sold for pennies on the dollar, yet so valuable. My other laptop was for my education consulting and youth development business that I've worked on for years. It contained irreplaceable workshops, trainings, customer documents, proposals, and my livelihood. One of the most hurtful things about this crime and these criminals is that they looked me straight in the face as they drove past me to exit the Goodwill parking lot, laughing, with no remorse as to what and who they had just victimized. I have committed my life to working with, for, and about disadvantaged youth. This person that violated me and others is beyond reproach as they have continued this criminal activity. He deserves nothing less than a maximum sentence as he has no want in his heart to stop victimizing the community. I thank you for your time and attention to this matter. Mestophia Frame.
Thank you, Ms. Rolak. And insofar as Mr. Frame is still listening through the YouTube feed, thank you, Mr. Frame, for sharing that. I think it puts a very human perspective on what the toll of entering auto crimes are. I think too often they're dismissed as nuisance crimes. Someone loses a phone or an iPad and insurance helps them get a new one. But you are helping, hopefully in particular, Mr. Carr understand that whatever he threw away in the end, photographs of your distant relatives, the contents of your laptop that might represent the lifetime of good works. It sounds like the kind of work you were in. You can't put a dollar value on that. You certainly cannot replace it, and it's gone. So you could sell a laptop for $50 or whatever happened. So I'm very sorry for your loss, and it doesn't sound like monetary restitution is going to make you whole, and it certainly won't make some of the other victims whole. But I appreciate you staying with this case 4 years later and making these types of crimes much more real and the loss much more understandable. I hope you're doing all right. All right, Ms. Crawford, question for you. Ms. Hall had done a lot of homework on Mr. Carr's priors, and she identified one open case. Do you agree that the 12 SC is still open?
Yes, Judge, that's correct. The 12 SC case is still open, and he does have 1 year, 2 months, and 10 days remaining on that case.
Got it. Okay. And that's 107157.
That's correct, 107157.
Okay. All the other ones, including the Cobb case, as far as you know, they are not open probation cases.
That's correct.
Okay. Thank you. Mr. Melnick, when we get to it, are you and Mr. Carr open to handling what would just in the future be a revocation matter in connection with the 12 SC case?
Yes, Your Honor. I've discussed it with Ms. Crawford.
Okay. We'll get to that. Ms. Rolak, was there anything else from any of the other victims, or Mr. Frame was the one impact statement you had?
I didn't have a written impact statement from the others, but everybody expressed how much pain they felt with regards to some sentimental stuff that was in their vehicles. In particular, Mr. Lee Rourke says that he had a journal that is of sentimental value that is completely priceless to replace, and he's still grieving that.
Okay, thank you. Mr. Melnick, what do you want to tell me about Mr. Carr and his situation?
Thank you, Your Honor. Mr. Carr is 26 years of age. He lives with his fiancee, Latavia Davis. After he was arrested on this offense, she gave birth to a child, and they also have 2 other children together. Right around the time that these allegations, that these incidents occurred, Mr. Carr's grandmother had passed away. His grandfather was extremely sick, and unfortunately, he hasn't handled this situation particularly well. Your Honor, obviously, I am sympathetic to the individuals whose cars were broken into. It's happened to me before. It's not a good feeling. I understand it entirely. But Your Honor, what I'm hoping we can effectuate through this sentence is that Mr. Carr can get out and be productive in his life and get away from this type of behavior. He has been in continuous custody since October the 31st of last year. Obviously, a lot of the delay in reaching this case has to do with the judicial emergency that we're currently still embroiled in, unfortunately. But I think this is a fair disposition for the case. I would ask that you allow him to accept this recommended sentence, to be sentenced as we've outlined. And as far as restitution, Judge, I've kind of lost track of things, to be perfectly honest with you. The note that I got from Ms. Hall this morning was that she was asking me for a little over $12,000 in restitution, which I said I'm just not, especially with this, with not having any more notice and without any more concrete documentation, I'm not in a position to agree to $12,000 in restitution. So I don't know if you want to just keep that open for now and let us try to sort that out a little bit. I don't think we'll need more than 30 days, but I think that's probably what we ought to do. Your Honor, I do think that it's important for Mr. Carr to get out and begin paying restitution as quickly as possible. I think that the restitution will, I think, at least ease some of what the victims in this case have gone through, as he has been in continuous custody since October the 31st, and he does have a family to go back home to. I would ask that the 1 year to serve be commuted to the time that he has already served, and that he be ordered to begin paying restitution. I think if we can come up with a restitution agreement within 30 days, he can start paying it within the 30 days of his release. If not, within 30 days of the date that a restitution order is entered into by the court.
Okay. Mr. Carr, anything you want to add?
No, Your Honor.
Tell me what your plan is to do something different. I am looking at the notice that got your case transferred from non-complex to, it was Judge Reeder initially, but now me. And in a pretty short span of time, 2013 through 2018, you picked up 6 convictions, a lot of them involved entering auto. You said something today in the hearing that it makes me a little anxious that you're gonna just keep doing this. You said, what I do, I can't remember which cars I broke into. And it's something you gotta stop doing. It's not gonna go well for your new baby child, your fiance, or your other 2 kids. So what is Mr. Carr's plan to take up another line of work?
First, Your Honor, I gotta stay away from the drug that I was on first and foremost, because once this is the same cycle. I do, like, it's sad, but I mean, you know, I be here, you know, to help me. I get myself together, I get out, I be okay for a couple of months, and then it's like, I just go back to the same habits. You know, I don't work, you know what I'm saying, with my stepfather helping, you know, doing like lawn service and all that, but it's like, once I started getting high, I'm just doing the same thing over and over again. Honestly, I need help with myself.
What substance or substances do you struggle with?
Percocets and alcohol.
Okay. Mr. Melnick, had you and Mr. Carr talked about any treatment solutions to his situation?
Your Honor, it's just difficult these days, in all honesty. You know, a lot of facilities still really aren't taking people. Certainly, I think it's appropriate to make at least a drug and alcohol evaluation and any treatment recommended a condition of his sentence. But there's just not that many, not any great solutions in that regard with the current status that we're in.
Ms. Hall, I want to make sure I didn't misunderstand your recommendation. And I realize yours expires today. I thought your recommendation was the year to serve, not the year reduced time to serve.
Yes, good for you.
Okay, that was a Melnick addition.
That was a Melnick addition, Judge.
Okay, makes it a
But,
little.
one other thing that I did want to mention, I'm not sure if I'd mentioned this before, Mr. Carr, in jail, Mr. Carr has managed to become a trustee. So he's managed to show responsibility, you know, to that extent after having been locked up and arrested for these charges. How long have you been a trustee for, Dontavi?
Like 9 months.
So pretty shortly after he got locked up.
Okay, got it. Well, Mr. Carr, I find there is a factual basis for your pleas in both cases, and that your pleas are knowing and voluntary. Knowing means you've understood what we have been talking about, and if you didn't, you did what I asked you to do, which was basically raise your hand, and you and Mr. Melnick were able to have a private conversation. Is there anything we've talked about that you are unsure of or you want to ask me about?
No, Your Honor.
Okay. A voluntary plea is one where you're not being forced to go forward. You may not be excited about it. I understand that, but no one has ordered you to enter a plea or threatened you to enter a plea. You've decided that it's time, as you put it, to put this behind you and try to move forward. Is that a fair statement?
Yes, Your Honor.
Okay, then I'm going to accept your pleas in both cases. And in both cases, I'm sentencing you pursuant to the Probation Options Management Act. And what that means is that when you are on probation, which you will be for a while, if you have a minor violation, I hope you have none, but if you have a minor violation, let's say you test positive for Percocet, you don't have to come back in front of a judge. You and probation are going to work on that and figure out a way to work through it. But if it's something more serious, new charges, you get arrested again, that'll come back to me, and I will work through with your lawyer and the prosecutor what we're going to do. In terms of restitution, what I need Ms. Hall to do is to send to Mr. Melnick. You may have done it as of this morning, but if not, if you could particularize by victim, because that's what probation is going to need in the end. I'm comfortable now with the way you've structured it. It allows Mr. Carr to go forward today because you could always re-indict and add the other 2016 that one of whom we heard from today. But another way to make them whole is to include as a condition of probation payment of those other lines of restitution. So if you haven't already, if you could itemize, by that I don't mean Mr. Melnick may want it. I don't mean Mr. Frame lost a laptop and this, but by victim the dollar amounts, and then you and he can talk. And what I'll do is if the dollar amount you all agree to is under 13,000, I'll simply modify the sentence. We don't have to have another hearing. I mean, by my math, it adds up to about 12,700, give or take. So if you and Mr. Melnick work through this and the figure you come up with is 13,000 or less, in other words, it's only getting better for Mr. Carr, then I'm comfortable amending or modifying that sentence without gathering everyone again. If it turns out that there's either a real strong factual disagreement, or you look at it again and you say, whoops, to be human Hall, it's actually 20,000. We need to get Mr. Carr and Mr. Melnick back in the loop because that's more severe than what we're talking about today.
Okay.
Right.
I have a question. So, how will it affect the plea if we don't come to a negotiation? Do I need to hold to the plea that whether he's not charged with the other internal? I wouldn't want to close that particular case and then we don't have an agreement on the restitution amount, and then I can do nothing to actually make him pay restitution because now we close the case on the one count of internal.
So I can't give you legal advice, but what I can tell you is that factually, Mr. Carr is only pleading guilty to breaking into Ms. Ogletree's car and no one else's. So if the state were to bring a charging document, if they were to bring an accusation, which is not required of an jury, for the other vehicles that you mentioned that day, I don't believe that that would be barred by double jeopardy because he hasn't pled guilty already to breaking into those other cars. His guilty plea is as to Ms. Ogletree only, but to avoid yet another set of charges, he's agreeing to cover the other restitution. So if restitution negotiations fall apart, I think you do have a plan B, but it's not legal advice, it's just an observation.
And if I could interject here briefly, Ms. Hall, so I mean, the only discovery I've received on that 20 SC case has to do with this one entering auto. So I would obviously want to take a look at, you know, not just the restitution amounts themselves, but also what the factual basis is for linking Mr. Carr to those other vehicles. But if that is, you know, I think you know that I can be pretty reasonable as long as that's proven to me satisfactorily. You know, that I'm willing to agree to do that so that we don't have to worry about Mr. Carr being further accused and facing the possibility of any additional jail time. Okay, so just, you know, make sure I have what I need.
I understand. All the information is in the report that you have.
Well, you guys can talk about this offline. And like I said, I'm comfortable modifying the final dispositions as needed. So we can narrow it. Mr. Melnick, your question / concern relates to the 20 SC case, not the dollar amounts for the 19 SC case?
Well, I just got those dollar amounts today, Judge, so I'm not trying to be too difficult, and I don't want to, you know, do anything to cause the plea not to go forward, but I really kind of need to see a little bit more on that too.
For both cases?
Yeah, for both cases.
I'm not pressuring, I just didn't know what was just in, and it sounds like for both cases.
Yeah.
So we'll revisit that as need be. So, Mr. Carr, I'm not inclined to accept your plea as an Alford plea in what I'm calling the Dugan's case, the one on Ponce, based on what I've heard. I hear you saying, you know, I can't tell you with specificity which cars I broke into, but it sure sounds like there is evidence aplenty that would show the guy with your palm print, which would of course be you, breaking into 4 cars at Dugan's and driving a vehicle in the process of doing so that resolves back to your address. So I don't know if that was your fiance's car. We certainly don't want to wrap her up in all this. But I need to let you know that I'm not inclined to take it as an Alford plea. It doesn't change the sentence you're going to get. But if you are insistent that you're not pleading to the Dugan's case, the 19 SC case, then we're sort of at a standstill with that one, but I'm happy to go forward with the 20 SC case. Tell me where you are with that.
I'm ready to get over it, sir.
Okay. We'll go forward with both those. Then here's how I'm going to sentence you. In the easier case, 20 SC 175155, which is the 1 count of entering auto, Ms. Ogletree back in April of 2016. I'm going to sentence you to a term of 6 years to serve 18 months with a balance on probation. I'm giving you more probation because I think you're going to need some time to pay these amounts, assuming that they are substantiated by the state. You'll get credit for all the time you've been in, and it will be a special condition of your probation that you enter into and complete the Metro Atlanta Day Reporting Center. And that is my way of addressing your concern about relapse. The Day Reporting Center is operated by the Department of Community Supervision, that's probation. And they will get you some drug treatment, some job readiness, et cetera, but it's some structure when you get out. You don't live there, you live at home with your family, wherever you choose to live. The point of adding that condition is an effort to avoid you going back to your old ways. Because next time it's going to fight you even harder. It's sort of enough is enough, I think, is what everyone's saying here. And I think you heard it through Mr. Frame's comments. There's some things you do that are irreplaceable. You're not out shooting people, I get that. But you are doing some things that leave permanent marks on people's lives. And that's going to need to stop. Let's shift to the other case, the 19 SC case. Your sentence there was run concurrently at the same time with sentence in the 20 SC case. For counts 1 through 4 will be 5 years to serve 18 months with the balance on probation. Counts 5 and 6 will be 6 years to serve 18 months with the balance on probation. And counts 7 through 9 will be 12 months to serve. All those run concurrently. So, oh, I didn't pronounce a legal sentence in the other case. So poor Ms. Nelson, who's having to listen to this, your sentence in the 20 SC case has to be 5 years, it can't be 6. It's 5 years to serve 18 months with a balance on probation. Still the Metro Atlanta Day Reporting Center. Restitution TBD, we'll see. I may modify the sentence there, depending on how the conversations go with your lawyer and Ms. Hall and you. The 19 SC case, the sentence is as I described. So counts 1 through 4 is the 5 to do 18 months. 5 and 6 are the 6 years to do 18 months. So there's a little more time on restitution. As long as you have completed the Metro Atlanta Day Reporting Center and paid off restitution, I'm comfortable making restitution non-reporting, even suspending it once you've taken care of the things you need to take care of. And then, as I mentioned, the last 3 counts, 12 months to serve. You'll get credit for all the time you've been in. And that leaves hanging the open probation, which is 12 SC 107157. And Mr. Melnick has agreed to waive the due process notice rights. And I'm comfortable today, in light of your 2 new convictions, revoking the balance of your probation in the 12 SC case, running that concurrently, meaning at the same time. So that case will be closed. When you get out, you will be on probation for these 2 cases. You'll take care of whatever restitution amount ends up being appropriate. And I'll amend those 2 sentences to reflect that. You can get back to your family. You'll be in the day reporting center and hopefully ready to start a new chapter. Ms. Hall, were there other conditions apart from restitution that you wanted in Mr. Carr's 2 cases? Okay. Mr. Carr, I have sentenced you a little bit more severely than what the state asked for. I think that's appropriate in light of the criminal history, the volume of the entering autos. I think what we've all heard, the impact of what you've done, and the fact that you were on probation when it happened. But because of where we are in the process, if you want to withdraw your plea because you think my sentence is unfair, you're free to do that, and we can move your cases towards trial. We have that right today to do that. But I think that this sentence is one that can help put all this behind you. It closes out that robbery case, and importantly, with the day reporting center, is getting you a little help along the lines of what you were asking. Do you want to go forward with your pleas, or do you want to withdraw your pleas?
I'll go forward, sir.
Okay. Mr. Melnick, any questions about Mr. Carr's cases?
So, Your Honor, on the 12 SC case, what we had talked about was revoking a year and closing the case. Are you doing something different than that?
I revoked the balance. It's less than, and I'll give him credit from the time he got in. So that was Halloween of last year.
Right.
That's a shorter term. That will not slow Mr. Carr's release.
I got you. Okay.
Ms. Crawford will be filling out the order of revocation. It will revoke the balance, which is 14 months, but Mr. Carr will get credit, as he should, for these 3 things, his 2 new cases and the revocation for all the time he's been in, not just because he's been a trustee. And you told us that was basically Halloween of last year.
That's correct, Judge.
Okay, anything else?
No, that's all. Thank you, Judge.
Last thing, I have copies of the indictments here in front of me. Normally, Mr. Melnick would sign the indictment, you would sign it, Mr. Carr, and Ms. Hall would. Because we're in this public health crisis, I am able to sign it if each of the parties authorize me to do so. Mr. Carr, do you authorize me to sign your 2 indictments on your behalf?
Yes, Your Honor.
Okay, Mr. Melnick
Yes, Your Honor.
and Ms. Hall.
Yes, sir.
All right, I will do that, and we'll take it from there. So, Ms. Hall, you will let Ms. Nelson know within 30 days or so if we are going to be modifying these indictments because of the restitution situation, and we'll take it from there. Okay.
Thank you.
Thank you, everyone. Mr. Carr, you're
Okay,
going to
another
go
question for so I mean, I have like 8 more months to do, sir.
at most.
Okay.
At most. There'll be folks who are doing the calculation based on the seriousness of your situation, but it wouldn't be any more than that.
All right, thank you.
Okay? Good luck.
Judge,
Yes.
I need to get some information from him.
Oops, Mr. Carr, hold on 1 second. Sorry, Ms. Crawford, forgot about that. Mr. Carr, Ms. Crawford is with probation. She will not be your probation officer, but she needs to get a sense of where you think Paul will be when you get out. And she'll give you some reporting information. She's gonna write down the best possible information. We'll go from there, okay?
Yes, Your Honor.
All right, Ms. Crawford.
Good morning, Mr. Carr. I need to get an address from you as well as a contact person's name and telephone number.
I mean, I'm probably not gonna have no address once I leave, so I don't.
Well, you mentioned that you work with your father some,
Yeah.
you use his address, but an address of someone who, when you got booked in, you had to give a next of kin name, that kind of thing.
3050
Garnett Way.
Garnett Way.
Hold on. All right, he's quiet now. Okay, so what's a name and address for Ms. Crawford?
I thought that he was giving.
Yeah, I think he did.
Oh, he was doing that?
Yeah, he can give it from.
Oh, I'm sorry. All right, Mr. Melnick, you need to unmute yourself. You were inadvertently muted.
Okay, I've got Miss Crawford. I have an address.
Okay,
Great.
3050.
Repeat that, Mr. Melnick.
I'm sorry. You want me to repeat? I'm sorry. 3050 Garnett Way, Atlanta, Georgia 30349. And the person he'll be living with is Senoia. That's spelled Senoia Davis.
Is that your house, Ms. Crawford?
no, sir.
That's coming from Mr. Carr's fiance's house.
Oh, okay.
Okay, and can I get a telephone number for Ms. Davis?
Yeah, it's 470-357-8068.
Okay, and I'll just give you reporting instructions. 48 hours after you're released, you're gonna need to report to 276 Memorial Drive, Atlanta, Georgia, 30303.
Thank you, Ms. Crawford.
Thank you.
All right, thank you.
All right. So Ms. Nelson, I'll just let you know, unless you heard from Mr. Gregory, he never showed up despite the show cause order. So we'll have to work through what that means in Mr. Peck's case. And that may be one reason why Ms. Hodge is there. Hey, Ms. Hodge.
Good morning, Your Honor. Yes, I am here for the Peck case.
Yeah, well, Mr. Peck was not brought over on purpose. This was simply
Right.
an opportunity for Mr. Gregory to explain himself,
Mm-hmm.
which he's doing by not being here. So I will take it from here and we'll figure out what's next for Mr. Peck. He did write a letter, Mr. Peck did. We'll get it in the record soon enough, but it just came last week. You'll be able to see what he has to say. I think he's just unhappy that he he's stuck. But we need to get him a lawyer so we can move the case along. Do you have any update on the Peck matter, Ms. Hodge?
No, Your Honor. So
Okay.
I'll just wait for further instruction from the court.
Sounds good. Thank you.
I'll see you at 2:30, I think, around 2-ish, later this afternoon.
All right, I'll be there.
All right, thank you. May I be excused, Your Honor?
Yes, ma'am. Thank you.
Thank you.
I think Vanderpool's next, but we need to figure out who his lawyer is. Well, it says, yeah, Mark Kerr. I don't know who that is, but it may be Mr. Franklin. It depends on whether if his lawyer's in person, I'll talk with them and we'll figure out how they want to do it. It may be the lawyer wants to be at podium and we have client at table. Okay. Did Mr. Franklin say it is? Great. Okay. Good morning.
Yeah.
Have you two talked about Mr. Vanderpool's situation?
In very limited detail. I've not received a petition yet, so
Oh,
we're
okay.
kind of talking in the dark. What we have loosely discussed is setting a date for an actual revocation and gathering the paperwork and hopefully possibly being able to cancel it before then.
Okay.
But
It's moved without providing address, hasn't paid, and didn't enter a program. So it's not, I don't know, it's one that you're gonna need to finalize witnesses for. I know you didn't have it, but they're technical.
okay. Oh, okay.
Oh,
Well, I mean, one of them is a special condition because he supposedly didn't get into the stand program. Not that he wasn't admitted, but that maybe he left it.
That makes sense, yeah, because we wouldn't have asked the sentence if we hadn't received indication that
Right,
he was getting.
that he could get in. I assume this is before my time.
Yeah, I think
That he
it
was
was
sentenced.
one of the last things we did was that.
Okay. And one other thing, Mr. Franklin, we're not on the record yet. The way we're working this, I think it was, you explained this to me. If you need time to talk to him, we'll all get out of the courtroom because folks aren't going back in the lockup. Do you want a few minutes to talk to Mr. Vanderpool?
Or what I need to have the conversation about, discuss that today.
Okay, however you want to do it, but if you need a chance to get loud, we can get it on. Mr. Franklin, you ready to go?
Yes, sir.
Great. All right. Let's go on the record with position 4. It's 19 SC 171473, State versus Mario Vanderpool. Is that how you pronounce it, sir? Okay. I'm Judge McBurney. I don't think we've met before. I think when you entered a plea in your case, it was with Judge Reeder. I now have her criminal cases, so we'll be working together on this case. Mr. Vanderpool, one of the reasons you're in jail, I don't know if there's others, but the one I know of is that there was a warrant taken out, I signed it, in connection with some struggles you were having on probation. So that's all we're going to talk about today, and we may only have a preliminary discussion. Mr. Franklin was helping me understand where we were in the process. But so you know, because you may not have seen a copy of the petition, the allegation is, Mr. Vanderpool, that you didn't notify your probation officer of a change of address, that you haven't been paying, I don't know if that's supervision fees, given the dollar amount of supervision fees, but maybe it's restitution. And then finally, you were supposed to participate in something called the STAND program, and the allegation is that either you didn't show up or you quit or you got kicked out. But those are just allegations. I'm going to ask Mr. Franklin how he wants to go forward today now that the two of you have spoken, and we'll see what the plan is. Mr. Franklin.
Yes, sir. So I've engaged in a brief conversation to get an understanding of what you had previously informed me, or the natures of the technical violations. Based on that conversation, and based on my other conversation with ADA Cassie Hall, we are asking the court for about a 3-week reset to do some background investigation. What he told me about these technicals, I believe we should be able to fairly easily resolve. But he also has an unindicted case.
New charges.
Yeah, he's on a CP case as well. From what I understand of it, I'm gonna get what paperwork I can get on it. I know the attorney on it, Mr. Renda Journey.
What are the allegations?
It's an aggravated assault involving his girlfriend.
Okay.
He will, I don't want to speak too soon. I will say that there's a possibility and a modicum of interest in possibly waiving indictment. From what I think the evidence will show in the case, including a lack of injury, it may be one of the cases where we could resolve the revocation alongside getting rid of the CP case and helping alleviate the backlog there.
Okay.
It's just a bit more conversation needs to be had, including getting a copy of the petition and getting discovery from the CP case.
Got it. Okay. I think that's a smart approach if it's one that works out in the end. What we could do, unless you and Mr. Vanderpool think that it's important that he be here in person, is we could set Mr. Vanderpool on one of our Zoom calendars 3-4 weeks out so that we've got a good date. Can always extend it if we need to, but then we know that we'll all be connecting again. If you think it's more productive that he be here because there could be a plea to an accusation as well, then we have these calendars, the in-person ones, that go smoothly every week. So we could 3-4 weeks out have Mr. Vanderpool brought back over. I think I speak out of turn because that's actually Ms. Nelson who controls all that, but she'll chime in a moment to let me know if that's okay. Does that work? I want to make sure we're not bringing him over and not enough has happened to.
Yeah, I'm picking up what you're putting down. I think that that's fine. And if we are at a point where I don't think it's gonna actually resolve, then we can cancel it or off it and schedule the formal revocation. But I do think we'll at least be able to have an agreement on the revocation and hopefully try to wrap the CP thing up.
Which do you prefer, in person or?
Zoom calendar is fine for that purpose.
Pardon me?
The Zoom calendar will be fine.
Okay.
Because I'm anticipating that it'll be essentially a plea or agreement to a resolution.
All right, 3-4 weeks out. We'll do that. So Mr. Vanderpool, we're not going to sort things out today. I didn't realize you had another piece of business that had you out of the jail. But Mr. Franklin's got a good plan. If it's workable, obviously it takes 2 to tango. Ms. Hall's going to need to look at things and see if the prosecution is going to go along with that. And if your new charges don't work out, that's not the basis for the revocation. You can't be revoked for something that's not alleged. Maybe that they amend this, but right now it's the technical violations. So we'll see you soon. It sounds like we'll do it via Zoom, so we'll all be on screens. You and Mr. Franklin, they'll speak privately if you need to, and we'll see if we can work it out. Ms. Hall, anything you want to add in connection with Mr. Vanderpool's case?
No, Your Honor.
You're okay with the general framework that Mr. Franklin described?
Yes, Your Honor.
Great. All right. Good to meet you, sir. Do you want to do Mr. Thompson or Mr. Let me ask Mr. Franklin because he's got both. How are you? All right.
If we could jump to Mr. Trim, I know his mother is online now.
Been on since 9 a.m.
Correct, we've been in contact. And
Okay.
additionally, I just received an offer from Mr. Thompson I need to convey.
Okay.
I'm gonna step to the back and grab my.
We're gonna do Mr. Trim. There's two cases.
Yes.
All right.
It's a body.
And is Ms. Trim gonna be saying something? She keeps showing up on the Zoom.
I gave her the
encourage
link.
to YouTube.
I don't anticipate her saying anything. It's a situation where I thought a question may arise from your position,
Having her right
so
there.
she's available.
Okay. Morning. All right, we are going to skip to positions 6 and 7. These are bond hearings for Mr. Trim. How you doing, Mr. Trim? I'm doing okay. Mr. Trim, you've got two cases that were indicted back in 2018. 162990, which is an armed robbery case, and then 162580, which is also an armed robbery case. Mr. Franklin, your lawyer, is going to talk to me for a little bit about why I ought to set a bond in your two cases. I'll hear from Ms. Hall, who's the prosecutor handling your cases, and there may be other folks I hear from as well, if there are alleged victims who want to be heard, and your mom is connected as well, so she may have something. Is that screen on? Good, so you can see the screen? Great, okay. Mr. Franklin, tell me about Mr. Trim in his cases.
Thank you, Judge. Harrison is 22 years old. He's been in custody since he was 20. He is a native of Mississippi. He lived in Jackson with his father until the summer before 11th grade. He was a pretty good basketball player, and he hoped at that point in time to maybe get a few more looks by colleges if he were in a bigger area. So for 11th and 12th grade, he moved to Atlanta with his mother. He lived with his mother for a while. He went to school. Because of some issues with the nature of how credits transferred from Mississippi to Georgia, he didn't actually graduate, but he has obtained his GED. At the time of his arrest, he was working two jobs. He was working for Willie's Mexican Cantina, and he was working for, FedEx and UPS, loading trucks and boxes and that kind of thing at a warehouse facility. He had even received a certificate, to my understanding, because not a lot of people make it at least a month in that job, and he had received a certificate acknowledging that he had made it longer than several people normally do, loading trucks and that kind of thing. The circumstances that bring us before the court at this point in time involve 3 allegations of armed robbery. They take place over the course of 1 week. I think one is like the 19th, the 21st, and the 23rd. So about 6 days. In each of the cases, 2 of them, I don't think the state will contest. The third, I believe they will contest, but I believe the evidence to be clear that he was the driver, not the actual person who got out and used the weapon. He certainly was the person who was the driver in 2 of the cases. Harrison I think this is one of those people who kind of just fell into a position hanging with some of the wrong people, and was talking to participation of certain things unknowingly. I believe that Harrison, his history, he has no prior criminal record. I believe that he has exhibited in my communications with him, my dealings with him, that he is capable of something greater, something more. And what I'm asking for is a signature bond, not to be signed necessarily today. We're asking for a signature bond that will take place on October 8th. And the reason we ask for that is because I've been in contact with a woman by the name of Abiodun, Abiodun Henderson. She is essentially the director of a program called Gangsters to Growers. It is a holistic agribusiness training program. Essentially what it does is it teaches kids how to farm, particularly they grow peppers. They take the peppers and create a hot sauce with them and sell the hot sauce, essentially fund the program. Additionally, it includes aspects of political education, yoga, farm education. I know with the students that she has in her program this year, they're actually getting ready to take a trip to Florida for shark therapy. They're gonna swim with sharks and learn some things. So it's really unique and different from a lot of the things that we encounter. And the level of exposure, I think, is just something that would benefit Harrison as much as it would benefit other children.
Where is the program based?
West side of Atlanta.
Is it residential?
I think they will assist with residents, but his mother lives off of Cedar Avenue, off of Bankhead, off of Donald L. Holloway. I visited her home. I was probably at the house 3 weeks ago. I met Miss Angela. I met her husband. I met, I believe it was a sister who lived at the home. So I've been to the house. His mom is especially supportive. And these charges are certainly a surprise to everyone who knows him. The reason we are asking for this program, Your Honor, and this release, it's a 6-month program, and we are essentially trying to prove ourselves to the state in hopes of getting an offer later on. I will be completely forthcoming. My initial conversations with Ms. McCauley, she's not in agreement with what I'm attempting to do, but I hope that under the circumstances that we are in, which is COVID has slowed everything up in a truly unique way. And I'm hoping to honestly take advantage of that fact, knowing that we have several other trials that we could likely call before his, before we're probably pressed to try his case. I think it's a 6-month program, so it will be over about April. And if he completes it, I think we have a better argument for mitigation, or maybe a backloaded sentence or something that will allow him to show that he's deserving of his freedom. In addition to the fact that he's been in for approximately 2 years already. I think October 30th, October 18th will officially be 2 years. We believe a curfew would be appropriate. The program, I believe, runs from 8 to 5, so we would ask for a curfew that only allows him out from 7 a.m. till 7 p.m. Whatever the most intensive level of pretrial supervision we believe would be appropriate. And I would even be willing to offer that part of his conditions be to just come to court once a week so that you can personally lay eyes on him and know that he's being accountable for those things that we're asking for. Because in light of the fact that he does have 3 cases, each of which carry a mandatory minimum, I know that what we're asking for is unusual, it's bold, but I also believe that it's deserving. Again, he has no prior criminal history. We would ask one condition. I know that the current curriculum, that should he be allowed to get out, they do have a trip planned for, of all places, Mississippi, early in the process. We would ask for permission to go and participate in that trip upon his actual acceptance into the program. I completed paperwork for the application progress on behalf of Harrison a week or so ago, and I should know by the 8th of this month that he is in fact approved.
The 8th, as in today, or the 8th of?
Oh, today is the, I should know sometime today, that he's actually been approved.
You have indication from the program that he might be, like, official word, or you have no
Okay,
idea?
official word. Based on unofficial word, I'm all but certain that he will be admitted. Ms. Henderson and I have had a couple conversations about it. And she is particularly interested in finding young men who are facing incarceration or currently incarcerated. And so based on our conversations, I'm confident that the acceptance is gonna come.
Okay, and then it would start on or about October 8th, which is why you're saying that's when the bond ought to be set.
It will start October 12th.
Okay.
One other fact that I will include, it does pay. It pays $15 an hour. And at some point after some other training is involved, it will be a 40-hour-a-week job.
So they must sell a lot of hot sauce if it pays $15. And how many
So
young
they've
men are in it at any one time? Ballpark.
Right now, I think it's 7, thereabout. I know that they also receive some grant funding. She made mention to me that they received most recently, the largest grant they've received, which is about $60,000 to assist in this kind of program. So that's what I can offer particularly about it.
Okay.
In terms of the Ayala factors, I don't believe that he's a threat to flee. He had been working 2 jobs. He has family living in the area. I don't believe he's a serious threat to community. He was not the gunman in any version of the allegations from what I can gather. I don't believe that he's a threat to commit further felonies because his association with those other persons, we see where it's led him. And based on my relationship with him at this point, I would like to think that my words and our conversations have imparted upon him the level and the heaviness of what we're dealing with.
Well, 2 years at Rice Street must be seen in.
Additional, yeah. And he has no priors, so I think that this was, for lack of a better term, a really bad week. Not just for him, but for those persons who are complaining witnesses in the case. And we would also offer that we do not believe he's a threat to intimidate any witnesses because all the victims in the case were strangers. These were not any persons that he knew. And I think with the conditions of release that we've offered, that it has that sufficient layer of security for the court to pull him out if he's not compliant.
Okay, this is a creative request. Ms. Hall, Mr. Franklin previewed that the state is not supportive of this. So you can tell me why, and help me understand. I was just calling out one of the cases. It doesn't look like they're co-defendants in either case. There's not a co-defendant in the 2 armed robbery case, the one ending in 580. So it sounds like you don't have information about if Mr. Trim was only the driver, who the other people were.
That is correct, Your Honor.
Okay. So tell me what you want to tell me.
Well, first, Your Honor, the state opposes bond in this case, and we do not support the program that Mr. Franklin is referencing. Now, we probably would have supported, and speaking with my supervisor as well, we probably would have supported had it been 1 armed robbery, no history, but these were a total of 3 armed robberies that happened in 2 days. One in which involved, not all 3 involved guns, but the one where the state believes Mr. Trim was the only person involved in that particular one. Counsel would disagree, but we feel that he was the person that did that particular armed robbery. That particular suspect, or who we think is the defendant, followed the stranger home to his house, and while he was getting groceries out of his car, he approached him and asked him for the money that he saw him get out of the ATM. When he didn't produce it out of his wallet because the victim put it in his pocket, the defendant hit him with the gun, and eventually he gave him the $300. The victim saw him get into the vehicle, that was the getaway car that was registered to Mr. Trim. And also, investigators were able to locate the phone that was also taken from the victim. It was pawned by the defendant, which the victim said it was only one person in that particular incident. The other two incidents, the state doesn't contest that the defendant was there, he was the driver. One involved the stranger being, again, at his home, he was at a mailbox at his home, and two individuals, which we do not know who those two individuals are, got out of the car, approached the victim, took his money. There was a friend that was watching who got in his car, followed this vehicle, which is the registered vehicle to Mr. Trim. He was able to get the license plate number, he lost the vehicle, but gave the information, the officers were able to tie, Mr. Trim again to that armed robbery. The other armed robbery, only involved two males, and that again involved a stranger who was leaving from his home, and they approached him and robbed him. In that particular case, apparently it was just two individuals. Mr. Trim was the driver. In that incident, we don't have those two individuals, don't know if they're the same two individuals that approached the victim in the mailboxes or not. Mr. Trim he don't have to, but we don't have any of that information. So with all of this that we had 3 armed robberies to 3 strangers, where although Mr. Trim probably don't know exactly where they live, other than the house that he was at, or we suspect he was at, he do know where their homes are located. So he could possibly intimidate our witnesses. And right now the state is offering 10 years to serve, which we believe is reasonable on all 3 of the armed robberies. And for those reasons, we don't support the program that Mr. Franklin has found. Now, we are still open to the negotiations. Ms. McCauley informed him of that last week. So it could possibly get better for Mr. Trim, but right now, this is where we are. And we feel that if he's let out on bond, he will. Although these are his first crimes, they are very serious armed robberies. So we feel like if he's let out, he will commit additional crimes.
The situation where the state contends Mr. Trim acted alone, what is it that connects Mr. Trim to that? I understand with the other 2, someone follows a car and it's Mr. Trim's car.
Yes.
And then he's a getaway driver in 2 of them, but the standalone, you may have told me and I'm not remembering, where you would contend to a jury, Mr. Trim was the only person involved. He followed the person home from the grocery store and hit him with a gun.
So the victim was able to see the car that the defendant got into, and he gave that information to the officers. That was the first incident where the car came back to Mr. Trim.
Okay, so the car that the armed robber got into is associated with Mr. Trim.
It's registered to Mr.
Got
Trim.
it, okay.
And he pawned the victim's phone in that case, and that came back on leads.
Okay, so those 2 things connect Mr. Trim to the event, but there may be a difference of views right now as to was the guy with the gun who whacked the victim with the gun Mr. Trim, or maybe one of these 2 guys about whom you've been told nothing from the defense.
Right, and
Okay.
I haven't confirmed with the victim if he successfully picked the defendant out in a lineup or not, so I haven't given you that information because of that. But those other 2 things we feel is strong enough to connect Mr. Trim to that particular armed robbery by himself.
Okay. All right, thank you for sharing that. Anything you want to add?
Yes, one, the incident, the most concerning incident, the one where the person was hit with the gun. Ms. Carl mentioned the fact that Mr. Harrison Trim is the person who connected to the pawn of I believe it was a phone, if that's correct. One of the other cases, he was also connected to the pawning of the object that was taken, where there was an ID, a 6-pack conducted, and he was not selected.
By the pawn shop owner or
By
by
the
the
person,
victim?
by the victim. Okay. And I believe the description was about, in that case, was of a person, 2 young men with afros, 2-inch afros. He's had the same dreads and twists in his hair since he was looking for
Okay.
so that couldn't be a fraud at that point in time. Additionally, in the case where the person sitting in the head with the gun, there's a body cam video of the officer talking to the man who's been robbed. And I mentioned this to Ms. Hall. I'm not sure if you had a chance to try to find the review it. And they asked, the officer asked specifically, what did he look like? What kind of hair did he have? Did he have braids? Did he have dreads? And you hear the guy, he doesn't have a great control name. But he appears to say it was regular. And the officer kind of paired that, okay, so it was black and regular, which would not be the description of his hair, which is why we feel so strongly about the fact that he's not the person who actually offered the actual violence.
Sure.
And also, his car will connect him to all cases.
Right. There's a certain similarity amongst all three in terms of vehicle and then maybe disposing of the stolen property. Okay.
And it kind of goes, and I typically don't preview kind of what would be my theory of the case, but I think it articulates further one of the reasons why we're asking for bond.
Okay.
Kid from Mississippi comes to the big city, has these, is hanging with people that he's not like necessarily. And I think for lack of a better term that he was used. Because in the other cases where a person was robbed, like he clearly, under nobody's version of events, is the one who did the robbing. Right. He's also pointing the objects, which to me suggests a level of sophistication from the other participants. Like, I'm going to send him, we're going to use his car, we're going to get him to use his car, we're going to get him to be the person upon it. Because those are the things that's going to come back and track someone.
Right. Okay. So, with your permission, Mr. Franklin, I may do a little research about this program. I've never heard of it. I'm intrigued by it, but presumably there's something online, but if there's not, I may ask you to provide a little more information to the state and to me. I'd like to learn about it, whether this is the program for Mr. Trim or not. It's going to be the program for someone who is in maybe a similar situation in terms of being criminal injustice involved, maybe not as seriously as these allegations. But I will take this under advisement because it sounds like I have a few weeks before something would happen. It would help if you let Ms. Hall and Ms. Nelson know, yes, he was officially accepted, because if he's not, it's all moot anyway. It sounds like he will be. And then I'll close with this observation. It sounds like regardless of the standalone indictment, meaning the one where the state is alleging Mr. Trim did everything but serve as the getaway driver, regardless of how that shakes out, it's still a real serious situation, in part because there are three. The storyline of mixed up with the wrong people resonates the first time, it resonates a little less the second time, and then there's a third time. So even if, when the dust settles, what a fact finder finds to be most credible is that Mr. Trim was merely the getaway driver and maybe the fence, or the guy who's on the stuff. The second and third one undercut a little bit the notion that he was just along for the ride, because if this was something that really concerned him, there have been only one rather than three. And I appreciate they're close in time, but they weren't 5 minutes apart.
Yep.
And that weighs against the notion of we got the, it doesn't sound like anyone's saying we got the wrong guy, but that he got involved with something that was a little bit over his head. That said, I'd love for there to be an outcome that doesn't result in Mr. Trim spending the next 8 years with no chance of parole. It sounds like the state's thinking about that as well. So let me learn a little bit more about the program, and we'll see where we get. It obviously would be helpful to know a bit more about the folks who really did have the guns in this situation, at least 2 of the 3. But, we'll see where that goes. So I'll look for information from you, Mr. Franklin, and you said it's okay if I do a little online research about the program to learn about it. And then Ms. Nelson will circle back with everyone. If we need to reconvene, we can do it in person or via Zoom. if I think it's important that we talk before October 12th. I wouldn't want to miss the deadline if I'm inclined to go forward with what you're proposing. And I appreciate the efforts you put into it, because again, whether this is something that works for Mr. Trim or not, it sounds like this is going to make it. I'm supportive of it. It sounds very holistic. I mean, in a good way, not like vitamin way. That it's something sort of like West Side Works, but dialed more directly towards young men who benefit from it.
So it definitely takes a unique approach.
Yeah.
To a common problem.
Yeah.
So
It's too bad it's as small as it is, but it's got to start small. Okay, Ms. Hall, anything else?
Mr. President.
Mr. Trim, do you have any questions for me? Not about your case or anything. Do you follow what I'm saying? I'm doing all right. All right, stay out of trouble. See you. So there should just be one more inmate back there. The lawyers are gonna chat for a minute. Then I guess the rest that we've got, is just lawyers talking, because I don't think we have Zoom in jail today. So just as an example, since, Ms. Snyder's right now looking for one of your cases. Why are you leaving? Oh, that's you. Yeah, okay. It says Leslie Simmons, but there's your name. So whatever we're doing with Cedric Taylor today, it's just we're talking to your client. You weren't expecting your client here, or he's walking in?
No, I'm not. It's just about discovery.
Good. Okay. I just want to make sure because we're only allowed 4 inmates, and number 4 is not anyone else on this panel. Okay. Good. Mr. Franklin, do you need a chance to talk with Mr. Thompson?
yes, but I think we can also make a couple of announcements that may get us back on schedule.
Okay.
Yeah. Or she may log on, may not. I told her she didn't need to because she's already completed the conditions of a virtual pretrial agreement. Position 11, Shelley Griffin. I've sent that documentation to Ms. Hall.
Okay.
And I drafted a null process order and I left it on my desk in the office this morning so I can email it to the court. But
Great.
position 11 will be null process.
No process statement.
Okay, so you've seen
I
proof of completion, state's okay with it, so that'll be a null process. You can email to Ms. Nelson or scan it. If not, I'm sure we can gin one up. That
Okay.
takes care of Ms. Griffin. Okay.
And position 9, he's actually in the hallway if I can grab him, but
Mr. McGuire.
yes.
Okay.
Let me grab him.
Okay. And Ms. Patel, I think you can hear. Can you hear me, Ms. Patel?
Yes, Judge.
Hey, how are you?
Good, how are you?
I'm well. I think position 10, Ms. Burton, we are all in agreement that Ms. Burton has done what she needs to do. And so, and Ms. Nelson may even have the null process, but if not, the state agrees that Ms. Burton has satisfied PTI?
Yes, Your Honor, that'll be a no process on the state as well.
Okay. All right. Is that your only case, Ms. Patel?
Yes, Your Honor.
Well, you did good work today.
Thank you, Judge. May I be excused?
Yes, ma'am. Yeah, wow, we are almost back on track. That's great.
And Your Honor, position 9, the state is also no process in that case.
Is this Mr. McGuire here?
Yes.
Hey, Mr. McGuire. Good to see you.
That one will have a little more detail inside of the order than the usual no process. We're going to include and Mr. Franklin will probably give more details with the incompetency part in our order.
So
Okay.
if you recall, this was right in the midst of when COVID was first hitting. I think this was around the early April. We attempted to do a plea, and by attempted, I went to the back and tried to get to a plea sheet, and I did not feel comfortable going forward. We asked for a bond, and he completed a eval while he was out. We've gotten the results back from the eval. He currently is not competent, and the opinion further upon that it would be questionable and laborious to restore him, and it wasn't a guarantee kind of thing. So I relayed that information to Ms. Hall and Ms. McCauley, in exchange, in consideration of judicial economy and Mr. McGuire's lack of substantial history, and the other factors. They've agreed to nullify this prosecute case in exchange for us agreeing to a permanent restraining order.
The victim in the case is former,
Mother of this child.
okay.
Um,
And she has a restraining order, this would make it.
She has the stay away,
CRO.
that's for the bond conditions command him to stay away, and he's complied with that.
Okay, and he's agreed to make that permit.
Yeah.
Okay, so that's why it'll be a more detailed order, and that will be coming from Mr. Franklin.
Yeah, I'll forward it, I'll courtesy copy Ms. Hall, and she can
Okay.
just say, yes, we agree to this one.
Okay.
And then you can sign it at that point.
Order coming. Mr. McGuire, that was a lot of words, but what I understand is that the state's gonna dismiss the charge against you, and you are agreeing that you are gonna stay away from the young lady who is the mother of at least one of your kids. Does that make sense? You willing to do that? Okay, well, good. I'll sign the paperwork that makes that happen, and you hold up your end of the bargain, okay? How'd you get down here today? Is she waiting outside somewhere? She gonna come pick you up? Okay, all right, train will get you home. All right, will you stay in touch with Mr. Franklin? He's gonna get me the paperwork, and that should take care of things. Do you need Mr. McGuire for anything else?
No, sir.
Judge Newkirk, how are you? It was supposed to be, and unfortunately IT misfired, and it's next door. So if you want to see it in action, you can go into 1C. It was supposed to be here. It's bigger, it's a lot bigger than one of those. It's on wheels, and it would have on the screen all the tiles you normally see in Zoom. But it would be, what it would broadcast is council table and podium. You be able to hear you, wouldn't be able to see you so much because it's angled out like that. But you still have your Zoom feed on your computer. That's how the world sees you. It works. Mr. Forte and I talked about it, and he says it's just easier if there are going to be people in court to see and hear them. But you've used Clear Touch. Have you been remote on Clear Touch ever? Have you been at home? Were you at home?
Yes, the first time that we used Clear Touch
The debut.
was not the best. That's why I decided to come in here. And it's only because sometimes council actually needs to stand by the system for it to pick them up. And then this courtroom being as large as it is, kind of got a cavernous cave echo effect to it. So it's just easy for me to hear. And right now, anything that I do through Clear Touch when I was not here, having to put through an equalizer to help be able to adjust the sound.
Your program, it would work better because it's smaller. And the fix was, because I watched it over in 1C as well, is you just had like Mr. Franklin were the one doing the talking, just go stand in front of the screen. So you feel a little silly because you're talking into the screen, but then the court reporter and Miss Kellicat covering one. She's one of the pool reporters, and we just had to have the participants get a little closer to the screen. Today's one is trying to refine it, and again, smaller courtrooms should work better. Sure. Likewise, it'll be a good Labor Day. All right, the only things we have remaining for this morning are Mr. Thompson. We have Mr. Carter, oh, that's you. So Mr. Carter, and then I think we're taking a plea in a little bit if folks show up. So what would you like to do next, Mr.
If I
Franklin?
can speak to Mr. Thompson, the latest new offer,
Sure.
We'll determine before we go.
So we'll bring him out here and, I'll just have Ms. Hall go into, jury room and, just give us a shout when you've had enough time.
I don't know. I don't know.
All right.
I just want to make sure I was prepared.
Yeah, I was like that. Okay, I'm good.
Hey, Mr. Franklin, just be patient, okay?
What do we do? Do we just do 12 months probation with the first?
You're ready for the job?
6 months? I'm on 6 months. No. I have to look at my notes, you know? I don't remember. I got it written down, though. I feel like I would have asked her. You asked for everything, sister, but I don't know if I agree to it.
I asked her and you were on that.
But you don't know what you asked for. I will. And I email you the phone. There. If I don't, if I don't, yeah. Okay, thank you. Yeah, we know person. We know first 9, 10, 11. Well, it's gonna be on Vegetation Freeway, I think. Yeah. Oh, that's it, I believe. What you say? You know you can't, I can't use that, man. You talking to yourself. Oh, yeah, yeah. Hmm? Who? Oh, yeah.
Before we turn to Mr. Thompson, I have a quick question about Mr. Carter, position 12, because he's on the Zoom now. Is that quick, or should I just let Mr. Carter know he should sit tight while we take care of Mr. Thompson?
It's quick. He was on the calendar. It's quick. He was on the calendar, because I think he was previously calendared and I wasn't able to. I was able to reach him by phone and I believe you received notice in the mail this time as well, correct?
Hey, Mr. Carter, how you doing this morning?
Good morning. How you doing?
I'm okay. Hey, this is Judge McBurney. Did you get something in the mail telling you you needed to join us today?
No, sir, I did not.
Okay. Well, we'll want to make sure we get a good address from you. How do you know to be on the call today? Because you're here, which is great.
Because of my bail bondsman.
Okay. Well, I'm glad they're earning their keep.
My attorney reached out to me previously.
Okay. So let me ask you a question. The address that we've got, I I got two addresses for you. One of them is on Flat Shoals and the other is on Morgan Road. Either of those good addresses for you?
No, sir.
Okay, then I'm gonna have you text to Mr. Franklin a good address.
Okay.
And then we don't need to get it on this big broadcast here, it's your business, but I need you to text to Mr. Franklin a good address for you. Don't get off our call until you get that to Mr. Franklin, and he'll tell me he got it, and then we'll get it entered into the system, okay?
Yes, sir.
Was there anything else, Ms. Hall, we were doing today with Mr. Carter, or just simply trying to track him down?
Oh, yes, just trying to track it down, Your Honor. Me and Mr. Franklin are talking about the case, but we're not there yet.
Do you feel like you've provided all the discovery that's out there?
No, I still need to provide the
Okay.
supplemental discovery.
Do you have it?
I don't, not yet. I've ordered it, but I haven't received it.
Okay, so it's stuff that's in process.
Yes, Your Honor.
Okay, all right. So, Mr. Franklin, you need more discovery. The state's trying to get it. You'll get an address from Mr. Carter. And once you let me know you received it, then we'll let Mr. Carter go and you can do that change of address.
Yes, sir.
Okay. Mr. Carter, do you have a number to text to Mr. Franklin?
Yes, sir. I'm doing that right now as we speak.
Great.
I just received a Fairburn, Georgia address from Mr. Carter.
Okay, so you're in Fairburn these days? Mr. Carter?
From my mother, I'm sorry. That's my mother's address, because I'm in the process of moving right now, and I don't know exactly how that's gonna work.
Got it. We'll just keep Mr. Franklin posted with your address, but we'll use the one for your mother's. And as long as Mr. Franklin knows how to reach you, we should be okay, all right?
All right.
Thank you for dialing in. You're good to go.
That's it?
For today,
Okay, thank you.
see ya. So Mr. Franklin, at some point today, you'll get that change of address.
I'm filling it out right now. You have it.
All right. Mr. Abate, are you covering the plea for Goodman?
Good morning, Judge.
Hey, are you gonna cover the Goodman plea?
Yes, Your Honor.
Okay, great. We're not quite there yet. We're running a couple minutes behind. But I see that we've got Ms. Hornsby Culpepper as well. So we've got and there's Mr. Goodman. So we've got who we need. And we will turn to that next. We got to deal with Mr. Thompson first, okay?
Thank you, Judge.
Good morning, Your Honor.
Good morning.
Good morning, Your Honor.
Good morning. All right, thank you, sir. Oh, I just got one last thing. Mr. Thompson hasn't ever been arraigned.
We'll wait.
You'll waive arraignment, so you'll fill out that form later as well. Okay, great. Just so we keep that moving along.
It's not going to be today.
No, I'm sorry, I misspoke. Mr. Carter. Let me make sure. Carter or?
Mr. Carter, I don't believe would have been named. I think he would have been named, a waive the arraignment.
Yeah, I think it's Carter, and I just misspoke, but I'm gonna get. Carter, yeah. So Mr. Carter is waiving arraignment based on the form you're filling out, and that'll take care of things for Mr. Carter. Mr. Thompson, sorry to keep you waiting. John Marshall. Marshall. Ms. Hall, is Mr. Thompson gonna be a plea? I'm gonna pronounce his name.
Mr. Thompson, yes, it is.
Ms. Snyder, can we sort your situation out? We skipped over Senator Taylor. Gosh, you need to speak up. What are we doing with, that's Ms. Sellers, who is on the call. Hey, Ms. Sellers. You're on mute.
Good morning, Judge.
Good morning. Tell me, Ms. Snyder, what's going on with Mr. Taylor's case? The note I have is that you asked for time to get discovery, or the state asked for time to get you discovery. Someone.
This is the case, you can tell that that never serial, he was terminated from because there was no file for him. The sellers got me discovery and gave me a new offer. There are a few supplements that are missing, so she did reach out to State Spring PD to get supplements. But I anticipate it.
Okay. So that may have been hard for you to hear, Ms. Sellers, just because Ms. Snyder's in a different corner of the courtroom. She was reminding me that Mr. Taylor was in Veterans Court. He got terminated. Not quite sure why he didn't go to Judge Newkirk, but he's here. And he's not here in the court, but we have his case. And that you had provided most of the discovery to Ms. Snyder as well as a reasonable offer. But there were a few other pieces that you, Ms. Sellers, were going to try to get from Sandy Springs PD. Do you have an update for us?
Your Honor, I would need a little bit more time to get those supplements. They weren't already in the file, so I'll need to request those from Sandy Springs.
Do you know specifically the things that Ms. Snyder is looking for?
We talked about it on Friday, and specifically in the police report. In the body of the police report, they stated that there were some supplements. And so I need to get those from Sandy Springs.
Okay, so
And I'm not sure what they are. I don't know if they're pictures or what.
Okay, but you have something you can direct Sandy Springs' attention to. You've got a report that talks about these things.
Yes.
Okay, how much time would you like before we pop Mr. Taylor's case back on an inquiry calendar?
At least 2 weeks, Your Honor.
Okay, what we'll probably do, Mr. Taylor's on bond. Okay, we will put it maybe 3 weeks out. Ms. Nelson will sort out the specifics. Ms. Snyder did indicate that she expects this to be a case that is resolved short of trial. So you guys can continue to explore that as well. But I'll give you a few weeks to get the info from Sandy Springs, and then we'll see where we are. Does that work for you, Ms. Sellers?
Yes, Your Honor.
Does that work for you, Ms. Snyder? Great. Okay. That's what we'll do. Appreciate everyone plugging in.
And that completes my business with the court. May I be excused, Your Honor?
Yes, ma'am.
Thank you.
Back to school. All right. Now let's turn to Mr. Thompson's case, which is going to be a plea. Everyone ready?
Yes, Your Honor.
Okay. So this is position 5, 20 SC 175084, State versus Arthur Thompson. Good morning, Mr. Thompson. Mr. Thompson, Mr. Franklin tells me that you are prepared to enter a plea in your case. Is that correct? Yes, sir. Ms. Hall is going to put you under oath. Once you're under oath, you'll need to answer her questions and mine truthfully and completely. It's important that we address your questions as well. So if at any point you have a question about what's going on, let Mr. Franklin know so we can talk about that, okay? All right, Ms. Hall.
Thank you, Your Honor. And Your Honor, for the record, the state is nullifying count 2, which is aggravated battery, and reducing count 1 to battery.
So this is the misdemeanor plea.
Yes, Your Honor.
Got it.
Mr. Thompson, can you please raise your right hand? Do you swear or affirm the testimony you should give in the matter currently before this court should be the truth, the whole truth, and nothing but the truth? You may go ahead. Please state your true, correct, and legal name.
Thompson.
And are you at this time taking or under the influence of any alcohol, drugs, or medicine?
No, ma'am.
Is there any medication that you normally take that you have not been given today? How old are you and how far have you gone to school?
Until, 11th grade.
How old are you?
51.
51.
And are you able to read, write, and understand the English language?
Yes.
Do you understand that you've been charged with aggravated assault being reduced to battery?
Yes, ma'am.
Do you understand that you have the right to plead either guilty or not guilty to that charge? And if you plead not guilty or remain silent, you may receive a jury trial.
Yes, ma'am.
I'm going to pause you for 1 second, Ms. Hall. I thought you were null crossing count 2 and proceeding with count 1. Did I have that backwards?
That's what I said, Your Honor, but I was relying on the calendar. So if
Calendar
that's
flipped.
okay.
Count 1 is aggravated battery, which I assume you were reducing to battery, and null crossing count 2. You can do it however you want.
That's fine, Your Honor. It didn't matter. I just went 1, 2 on the calendar.
Yeah, calendar has it backwards, but I want to make sure that the defense is neutral as well.
Okay.
Okay, so count 1, aggravated battery, is being reduced to battery. Count 2, aggravated assault, is being dismissed for null cross. So we're still where we were, the misdemeanor plea, to 1 misdemeanor of battery.
Thank you, Your Honor.
Great.
Mr. Thompson, have you had enough time to speak with your attorney, Mr. Franklin, about all the facts and circumstances known to you regarding the charge in this indictment, including any potential defenses?
Yes, ma'am.
Do you need more time to discuss this case with your attorney?
No, ma'am.
Are you satisfied with his services?
Yes, ma'am.
Counsel, do you waive formal reading of the indictment?
So wait.
Do you waive any and all defects in the indictment, including with respect to the defendant's name?
Yes, any for purposes of this plea.
And do you waive moving forward on a copy of the indictment?
So wait.
Mr. Thompson, have you been arrested on these charges?
No, ma'am.
I ask because the state is unaware.
Say. Yes. Yes, ma'am.
I
You
ask,
have been arrested. Yeah, correct.
I ask because the state is unaware of any outstanding warrants that are related to these charges. Do you or your attorney know of any outstanding warrants related to these charges?
We are not aware of any outstanding warrants.
Mr. Thompson, has your attorney advised you of the minimum and maximum sentence to the charge that you're pleading to?
Yes, ma'am.
Maximum for battery is 12 months to serve. And do you understand that this is a negotiated plea of guilty, which means the state will recommend to the court a sentence of 12 months to serve 188 days, balance suspended. But the court does not have to accept their recommendation. The court can sentence you to the maximum on this charge, which is the 12 months to serve. Do you understand? Do you understand this is a guilty plea, which is permanently recorded on your criminal history?
Yes, ma'am.
Do you understand this plea may be used to enhance sentencing or other convictions in this jurisdiction, as well as other jurisdictions, including the federal courts?
Yes, ma'am.
Do you understand if you're currently on probation or parole, your probation or parole may be revoked based on you entering a guilty plea today? Do you understand if you're placed on probation of any kind, you cannot violate any criminal laws of any governmental unit or any special conditions of probation without being subject to revocation for the balance of the
Yes, ma'am.
Do you understand that you're not allowed to possess or use a firearm while on probation?
Yes, ma'am.
Do you understand if you're not a United States citizen, a guilty plea conviction will affect your immigration status and will result in deportation, just as a conviction at trial would, and this is true regardless of any advice by your attorney or anyone else. Excuse me. Do you understand that there may be other adverse or unfavorable consequences as a result of this guilty plea conviction, just as there would be following a trial, following a conviction from a trial? For example, your guilty plea may affect your right to vote, your right to hold public office, your right to serve on a jury, the right to obtain a passport, the right to receive, possess, or transport a firearm, or the ability to obtain employment. Do you understand that by pleading guilty to a felony, if you use, receive, possess, or transport a firearm, or use a firearm in a crime, you will be guilty of a felony, which may carry a sentence of 1 to 15 years in prison? Do you understand that you waive any and all defenses, including any mental health defenses, by entering a plea of guilty? Do you understand that if you went to trial, you have the right to a trial by jury, the right to see, hear, and confront witnesses called to testify against you, and the right to remain silent and not incriminate yourself? Do you understand that by pleading guilty, you're giving up the following rights? I'm gonna name a list of them, and then when we're done, you can say if you understand. The right to a trial by jury, the right to remain silent and not incriminate yourself, the right to confront witnesses against you, the right to the assistance of counsel hired by you or to court-appointed counsel, the right to the presumption of innocence, the right to testify on your own behalf and to present other evidence, the right to subpoena witnesses and compel the production of evidence, the right to have the charges against you proved beyond a reasonable doubt, and the right to appeal if convicted of these charges after a trial. Has anyone forced, threatened, or promised you anything to get you to enter a guilty plea today? Is it your decisions to waive these rights and enter a guilty plea because you're infected? How do you plead to the one charge of battery in indictment number 20-SC175084? Is this guilty plea freely and voluntarily given with full knowledge of the charge against you? Do you understand that you only have a limited right to appeal this guilty plea conviction? Do you understand that you only have 12 months from today for a misdemeanor charge to file a habeas corpus petition challenging the voluntariness of this guilty? Thank you. Your Honor, the state is aware of 6 prior convictions by this defendant, dating back, the oldest one, the most recent one is 2012, which was a prohibited item by inmate on, incident that took place inside of the institution. But then before that, there was a 2008 case that he still has open probation on. It's active, 3 years, 4 months, and 28 days remaining. If you want more specifics about older cases, I have them. But if this case proceeded to trial, Your Honor, the state was proven that on January the 10th of this year, 2020, at 1678 Richmond Avenue, Southeast Atlanta, Georgia, in Fulton County, officers responded to that location and investigated an attack by the defendant to his roommate. Apparently there was a dispute about the defendant receiving his check and paying rent. That conversation escalated to a fight where the defendant struck the victim with some type of object. The state initially thought that the victim had fractured his jaw. And once we received the medical records, provided that to defense counsel, read over those medical records, it was determined that the fracture that the victim did have, it was acute. It was something that happened well before this incident. That's why the state has decided to reduce this case to battery, Your Honor. That is all from the state.
The case that has 3 years and some months remaining probation, is that a Fulton County case?
I think so, Your Honor. One second.
Yes, it is, Judge.
What's that case number, Ms. Crawford?
Thank you, Ms. Crawford.
You're welcome. That case is 08 SC 65418.
Okay, and what was the charge?
Burglary, felony.
Okay, thank you. And the recommendation was 188 days?
Yes, it's essentially what he served to this day.
Sure, the magic behind that number would be time served.
Yes, Your Honor.
Okay. Mr. Franklin.
The only thing that I added on, I believe the statement spoke, she said that the acute injury, it was a remote.
I did.
Yeah, so, I mean.
Remote as in remote in time.
Yes.
Yeah.
The jaw was injured well before getting hit by whatever object Mr. Thompson may have
That is correct. We also put forth that, we believe that the amended charge, is correct to the extent that there was no object that he used, in this encounter. The complaining witness, we believe, was intoxicated, acting accordingly. They had words and they fought.
Okay.
So just it's a regular fight. It's a regular fight. No serious injury. So we believe that the offer is appropriate. That's why we're saying.
Okay. Mr. Thompson, when you get out, are you going back to the same place to live?
No, sir.
Where are you gonna live? Okay. Mr. Lawrence, your roommate, is he someone you knew for a while or just happened to be a roommate? Okay. You guys parted ways now? Okay. He's not in Clayton County?
We've not been able to find him.
Okay. Well, maybe it'll be good if it stays that way. Do you have any questions? New York?
White Plains, Georgia, somewhere.
Oh, okay. All right. Where's White Plains, Georgia?
I just heard of White Plains.
Okay. Do you have any questions about anything, Mr. Thompson?
No, sir.
All right. Well, I find there's a factual basis for these revised charges. You and Mr. Lawrence got into an argument. What were you guys arguing about?
But we were in the house, and when he got paid, we had to pay our rent, so he booked on, we got a check, tried to go right away. Then I got on to him about it, and when I got on to him, he pushed me, and I hit him.
Okay. So you were trying to get him to pay his part of the rent. And then it got physical. You look like you got pretty big arms. It might have hurt when you hit him. But I do find there's a factual basis that you hit him. Not supposed to do that. He shouldn't push you. I find that your plea is knowing and voluntary. I will follow the recommendation of both sides. It's a misdemeanor. I'm sentencing you to 12 months to serve 6 months with the balance suspended. And Mr. Franklin, I'm happy to revoke 6 months credit for time served in the burglary case, so this doesn't sneak up on him. Any issues with that?
No issues. We made,
Notice? Okay. Mr. Thompson, in your old burglary case, 08SC 65418, as a result of this new conviction, this misdemeanor, I'm going to revoke 4 months and 28 days, but you'll get credit for all the time you've been in. So you've already served 4 months and 28 days. So you'll have 3 years remaining of probation in your burglary case. This new case, the one where you and Mr. Lawrence got into it, there's no probation, there's nothing. You get released today or tomorrow. If you're not, let Mr. Franklin know, we'll fix the problem. And this case is closed. All right?
Thank you, sir.
Good luck in Clayton County with your sister. Ms. Hall, anything else? All right, thank you, everyone.
Judge, I'm sorry. Can you repeat that, please?
Yeah, we got to do 2 things. Don't leave. It's the sentence is 12 months to serve 6 months with the balance suspended.
Okay, thank you.
And Mr. Thompson, normally we pass around the indictment. You would sign it, your lawyer would, and the prosecutor would. Do you authorize me to sign the indictment on your behalf? Okay, Mr. Franklin?
Yes, sir.
Ms. Hall? Great. I'll put your signatures on the guilty plea. I'll indicate that it's to a misdemeanor to count 1, and then we'll stamp the indictment that dismisses count 2. All right? Thank you.
Judge, one thing from me.
Oh, yes.
I just know a credit from date.
When did you get arrested, Mr. Thompson, the day of the fight?
He was arrested March 5th.
March 5th. Okay, why did you get arrested?
So, yeah, go around me for that.
Excuse me, keep showing them. Sorry.
Like they had a warrant out for it.
Okay, and how did you come into contact with the police in March? Did you get a ticket or?
I'm so called place I'm working at, they went down to the place where I'm working at.
Wow, that's serious police work. Okay, so March 5th, 2020. Now you can go. We won't drag you back in again. Thanks. All right, by my view of the calendar, I think we're on Goodman now. Yes, we are on Octavius Goodman. And we've got Mr. Culpepper, we've got Mr. Goodman, and we have Mr. Abate present for the state. And Ms. Rolak, and there is Ms. Smith. So orient me, please, as to who Ms. Smith is, and then I'll know who all is involved. Is she on the victim side?
Yes, Your Honor. That's the mother of the victim, Miss Catherine Moore.
Great. Ms. Smith, are you able to hear us?
Yes, sir, I am.
Great. Okay, thanks for your patience. We, I think, are going forward with a plea, Ms. Hornsby, is that correct?
Yes, sir.
Okay. We've got everyone we need. Are you good, Mr. Forte? We'll take this plea and then have our break. Okay. All right. So, Mr. Goodman, before we start the plea, there are a couple things I need to cover with you. Are you able to hear me?
Yes, sir.
Great. Mr. Goodman, in normal times, you would be in court with Ms. Hornsby seated next to you, but you are wherever you are, where you're entitled to be. And Ms. Hornsby is not by your side. Do you waive your right to be present in court, Mr. Goodman?
Yes, sir.
Okay. And you waive your right to have Ms. Hornsby by your side during this plea conversation that we're going to have.
Yes, sir.
You should know that even though Ms. Hornsby is not by your side, if you need to speak with her in private, it's very easy to move you and her into what we call a breakout room, where it'll be just the two of you, and what you say, I cannot hear, no one else can hear it, or it'll be like if you were in a private room, you and Ms. Hornsby. So if you need that, or Ms. Hornsby, if you believe that becomes necessary, let me know, and I'll move the two of you into the breakout room until you're done discussing what you need to speak of in confidence, okay?
Okay.
Great. With that, I'm going to have Mr. Abate swear you in, Mr. Goodman. So in a moment, you're going to raise your right hand. Once you're under oath, it's important that you answer all questions truthfully and completely. So if at any point we start talking about something that does not make sense to you or is not what you were expecting, will you let me or Ms. Hornsby know?
Yes, sir, I will.
Great. Mr. Abate.
Judge. Mr. Gooden, if you please raise your right hand. Do you swear or affirm that the testimony you shall give in this matter pending before this court will be the truth, the whole truth, and nothing but the truth, sir?
Yes.
You can put your hand down. Thank you. If you could, sir, would you state your true, correct, and legal name for the record?
Octavius Jamal Gooden.
Okay. And Mr. Gooden, are you at this time taking or under the influence of any alcohol, drugs, or any other medicines?
No, sir.
And is there any medication that you take on a daily basis that for some whatever reason you were unable to take today that it would affect your ability to understand this, what you're doing here today?
No, sir.
And Mr. Gooden, how old are you and how far have you gone in school?
27 and 2 years of college.
Okay. And sir, are you able to read, write, and understand the English language?
Yes, sir.
And do you understand in indictment number 19 SC 171376, you are charged with the following offense, serious injury by vehicle?
Yes.
And the minimum that charge carries is 1 year, the maximum being 15 years?
Yes.
And you also understand that your attorney and the state's attorney, Mr. Pinion, have worked out a negotiated resolution or plea to present before your honor. That would be 2 misdemeanor driving charges to replace the serious injury by vehicle.
Yes, sir.
Okay. And do you understand that for each misdemeanor that you'd be pleading to, the minimum is 1 day and the maximum is 12 months?
Yes, sir.
Do you understand, sir, that you have the right here to plead either guilty or not guilty to these charges? And if you pled not guilty or remain silent, you may receive a jury trial?
Yes.
And Mr. Gooden, have you had enough time to speak with your attorney, Miss Hornsby Culpepper?
Yes, I have.
Okay. And at this time, do you have any additional questions for your attorney?
No.
And
No,
are you
sir.
okay? And are you satisfied with her services?
Yes.
Ms. Hornsby, do you waive the formal reading of the indictment?
We waive.
Do you also waive any and all defects in the indictment, including any with respect to your client's name for the purposes of this plea?
Yes, we do.
Okay. And again, Mr. Gooden, do you understand that this is a negotiated plea of guilty, which means the state, along with your attorney, will make a recommendation to the court of a sentence and a reduction to the 2 misdemeanors, but the court does not have to accept the recommendation and can sentence you to how he sees fit up to the maximum on each of the charges?
Yes.
Okay. And do you understand that he can run the reduction of the charges, the 2 misdemeanors, he can run them consecutively, which would be up to 24 months incarceration?
Yes.
Okay. And do you understand that this plea may be used to enhance sentencing on other convictions in this jurisdiction, as well as in other jurisdictions, including the federal court, sir?
Yes, sir.
And do you understand that if you are currently on probation or parole, or your probation or parole may be revoked based on you entering a guilty plea here today?
Yes.
You also understand that if you are not a United States citizen, a guilty plea conviction will affect your immigration status and will result in deportation, just like a conviction at trial would. And this is true regardless of any advice given to you by your attorney or anybody else, sir.
Yes.
Okay. And do you understand that you waive any and all defenses, including any mental health defenses, by entering a plea of guilty here today?
Yes, I understand.
Do you also understand that by pleading guilty, you're giving up the following rights: the right to a trial by jury, the right to remain silent and to not incriminate yourself, the right to confront witnesses against you, the right to the assistance of counsel hired by you or court appointed if you were unable to afford an attorney at the trial of your case, the right to the presumption of innocence, the right to testify on your own behalf and to present other evidence, the right to subpoena witnesses and to compel the production of evidence, the right to have the charges against you proved beyond a reasonable doubt by the state of Georgia, and the right to an appeal if convicted of these charges after trial. Do you understand that by taking a guilty plea here today that you're giving up or waiving all of those rights?
Yes, I understand.
Or has anyone forced, threatened, or promised you anything to get you to enter a guilty plea here today?
No.
Okay. And is it your decision to waive these rights and enter a guilty plea because you're in fact guilty?
Yes, sir.
And sir, how do you plead to the reduced charges in indictment number 19 SC 171376? The first being too fast for conditions or basic rules, which is 40-6-180 under the Georgia Code, as well as a failure to maintain lane, which is OCGA 40-6-48. How do you plead to both of those misdemeanor charges, sir?
Guilty.
And is this guilty plea freely and voluntarily given with full knowledge of the charges against you, sir?
Yes.
And do you understand that you may only have a limited right to appeal this guilty plea conviction?
Yes.
Okay. And do you understand that you have only 12 months from today for a misdemeanor charge to file a habeas corpus petition challenging the voluntariness of this guilty plea?
Yes, I understand.
Okay. And your attorney explained to you what a a habeas corpus petition. You have any further questions for her as it pertains or relates to that?
Yes, she told me.
Okay, and no further questions about it.
Do you have any questions about what a habeas petition is, or are you good to go? Mr. Goodman?
I'm good to go, Your Honor.
Okay. Your Honor, had this case proceeded to trial, the state would have been able to show beyond a reasonable doubt that on September 16th of 2015, in the area or at the location of 2256 Barge Road here in Atlanta, Georgia, Fulton County, the victim, Miss 12-year-old Catherine Moore, was walking down Barge Road with her brother and her brother's friend. As they were walking, it was about 8:10 in the morning, a little after 8 in the morning. The defendant came down the hill. He was driving his 2005 Ford Mustang. As he was driving down the hill, he, after speaking to the police, indicated that he had dozed off or had fallen asleep momentarily. When he did, he veered to the right and struck young Miss Catherine Moore, injuring her pretty severely on her leg and other areas of her body, causing serious injury to her. At that time, Mr. Goodman did remain on scene, did speak to the police. The officers who responded were able to speak to Miss Moore's brother, Shannon Moore, and his friend Terrence Cole, who were able to explain what they saw, that they saw the defendant's vehicle coming over the hill at a higher rate of speed, and that it veered to the right and he lost control. And that's when he struck Miss Catherine Moore on Barge Road on that day, Your Honor. That's what the state would have been able to prove had we proceeded to trial. The state has had a lot of conversations with defense counsel, Ms. Hornsby Culpepper. I spoke to Mr. Pinion, who's been primarily handling this case, and they have come to a negotiated resolution to present to Your Honor the 2 misdemeanor charges that would run consecutively on probation, which would make the defendant be on probation for 24 months. And a special condition of probation is that the defendant pay a restitution amount to the victim, Ms. Catherine Moore, in the amount of $10,000. And that amount would be, he would have made all the payments that would have added up to, that will add up to the $10,000 within the first 12 months of his probation, Your Honor. The defendant does have no felony convictions, no felony history at all, actually. And that played a part into the decision of Mr. Pinion or the state. I know that the victim's mother, Ms. Smith, is on the Zoom call, as well as Ms. Rolak, our victim witness advocate. And when Your Honor deems appropriate, Ms. Rolak does have a victim impact statement to read on behalf of the victim and her family.
Thank you. I have a couple questions for you, Mr. Abate, and then I'll turn to Ms. Rolak. You mentioned that there are 2 misdemeanor charges.
Yes, Judge.
The procedural question I have is, how does one turn a 1-count indictment into a 2-count plea? I'm happy to take it, and clearly everyone agrees, so it's not like there's going to be an appeal. And this is going to probation, it's not going to Department of Corrections. But I just want to get the state's take on how I can add counts to a plea from a 1-count indictment.
Your Honor, the state would submit to Your Honor that they are both would be included, I guess, as lesser included, but they would be separate lesser included of the serious injury, making those 2 lesser included made, I guess, the serious made the felony, made it a serious injury by vehicle. If Your Honor, if it's cleaner for Your Honor, I could always do an accusation, putting both of the misdemeanors on there. That way there's no confusion. But I believe that they're both, separate and apart. They wouldn't merge. They're lesser included.
Okay. The second question in that area is for you to give me again the first code section. I got the second one was 40-6-48, failure to maintain lane. The other one, it whizzed by me. So
I'm sorry.
Okay.
It's OCGA 40-6-180, and it's called Basic Rules or Too Fast for Conditions.
Okay, so it's not quite speeding, it's too fast for conditions.
Yes, Your Honor.
Got it, and then failure to maintain lane that clearly happened. All right, last question, I think, for now, for the state. Did you say in your recitation of the facts that Mr. Goodman stayed on scene or he did not stay on scene?
He stayed on scene, Your Honor. He stayed on scene and spoke to the responding officers after 911 was called.
Okay, got it. And the only person injured was Ms. Moore. Her siblings, fortunately, were not also struck.
That's correct, Your Honor.
Okay, all right, thank you.
Yes, Judge.
Ms. Crawford, you confirm no criminal history for Mr. Goodman?
That's correct, Judge. He has no record found.
Okay, thank you. So Ms. Rolak, I am happy to hear directly from Ms. Smith or from you on behalf of Ms. Smith. How's it going to proceed?
Judge, I plan to read the victim impact statement, and I also want to acknowledge that Catherine Moore is also on the line without video, as well as her father, Shannon Moore.
Okay, I didn't want to reveal, but I did see Catherine Moore had dialed in, and she is very welcome here. Why don't you share with me, Ms. Rolak, what her family has put together?
Good afternoon, Judge and Counsel. I am writing this statement on behalf of my daughter, Catherine Moore, the injured party in this case. Just so that everyone involved is aware, Catherine is still feeling the effects of the defendant's negligence to date. Catherine suffered a broken left femur bone, which according to her doctors is the hardest bone to break in the human body. She has had to endure 3 surgeries and had to learn to walk again after each of them. The incident broke the growth plate in her knee, causing the leg to grow at an angle and not grow to its full potential. This required that her right leg be shortened to match the left. As recent as the past few weeks, she has been experiencing pain in her right leg. Actions and choices can have far-reaching consequences. This incident not only impacted Catherine, but our entire family. It impacted her brother, who witnessed his sister being hit. Our whole family has had to pull together to help because this incident made an otherwise very active child scared to get up out of her seat to use the bathroom due to the pain she knew she would have to endure. We all had sleepless nights trying to keep her comfortable. At the end of the day, I am just glad he didn't take her life. I hope Mr. Goodman has and will make better choices in the future. In closing, I would like to say, Judge, I believe Catherine would benefit greatly from a show of remorse from Mr. Goodman, because although his intentions may not have been to harm, his actions greatly impacted an innocent child, and she will feel that impact for the rest of her life. Thank you for your time and attention. Carissa M. Smith, mother of Catherine Moore.
Thank you, Ms. Rolak, and thank you, Ms. Smith. I know you can hear me and see me. I want to remark now, and I may have something to add a little bit later, that I have been very, very impressed with the way in which Ms. Moore's family has processed this. This was a tragedy, and it sounds like it's something that Catherine will literally live with for the rest of her life. But I think they have appreciated the distinction from this case, between this case and many of the types of cases I see here. And that is that whereas Mr. Goodman in this case was being reckless, we don't have someone who had the ill intent. It wasn't a, I'm going to shoot you because I'm mad at you or you didn't give me your wallet. And so in that important respect, it is a scenario where I hope it's a little easier to forgive someone for his mistake. I'm not going to call it an accident because it sounds like maybe it wasn't safe for Mr. Goodman to be driving the way he was driving. And none of this makes young Catherine any better or her legs healthier, but at least think it's healthy that the family has processed this as Mr. Goodman isn't an evil guy, but he was certainly a reckless guy, and I trust he will bear this with him as he moves on. So thank you, Ms. Smith and Ms. Moore and Ms. Moore-Spotter for the way you have handled this. I do have a couple questions. Ms. Rolak, Catherine is how old now?
17. She said 17.
17, okay. Got it. And the restitution will address already incurred medical expenses, or it will address things that insurance did not cover, or it will address future expected medical expenses, or all of the above?
Judge, my understanding is the medical expenses have not been completely covered.
Okay. At a minimum, it will help.
Yes.
All right. Well, I appreciate that. And again, Ms. Smith, thank you for putting down in writing, summarizing your family sentiments. Is Catherine at age 17 in high school now? Great. Junior or a senior?
She's a junior. She's taking dual enrollment classes, so she's actually also registered with Chattahoochee Tech while she's in high school.
Fantastic, but it's all virtual right now?
Yes, definitely.
Okay. I'm glad that's happening for her. Okay. Well, let me hear from Ms. Hornsby, and then at the appropriate time, I'll ask Mr. Goodman if he has anything he wants to add. Ms. Hornsby.
Yes. Good morning, everyone. Anybody who knows me knows this right here is an emotional plea for me. I'm a mother and a grandmother. And I met Mr. Goodman a while. He came to me probably pre-pandemic on this case, and we've talked often, and we've actually prayed about it often. But he will talk. He wanted to make a statement, and he will talk after I finish. But as he told everyone, he's 27 years old. He's the father of one son. So he has a child, and he understands the need to protect our children. He finished high school, and he started at Benedict College and has done 2 years. He works at Walmart. He's a hardworking young man. He works in the warehouse type of job, but he's been there almost 3 years. It's been steady. At the time of this incident, he was working at McDonald's, and he worked like 2 shifts that night and had just gotten off. And it was 7, 8-ish in the morning, and he fell asleep. And I think, that's something he's going to remember for the rest of his life. Not that I know Ms. Moore has to live the ill effects of it, but it will be in his heart the rest of his life. He has a fiance and he wants to get married, and he wants really $10,000. When I look at a guy that works he's not a rich man, but he wants to do this. He has always wanted to do whatever he could to make this right. And unfortunately, money is the mechanism, but we've prayed for Ms. Moore. We prayed for her full recovery because we believe that it can happen and will happen. We just thank the family of Ms. Moore and Ms. Moore for being gracious in your hearts to allow him to take these misdemeanor pleas and take responsibility for what he did that day that changed her life. We respectfully ask your honor to accept these pleas. we have $500 we just itching to get out our hands now to start as good faith. We know that the 12 months, will give him time working at Walmart and paying child support and taking his family to be able to do it. We're just gracious and grateful that he is allowed this chance. So we just ask respectfully, Your Honor, to accept the negotiated plea that has been worked out by me and the state. Thank you very much. Thank you, Ms. Smith and the Moore family.
Ms. Hornsby, do you believe, and I'll ask Mr. Goodman this in a minute, that 12 months is enough time for Mr. Goodman to amass $10,000? Now it sounds like it'll be $9,500 because there's money that is already earmarked to go through misdemeanor probation to get to Ms. Moore and her family. But I don't want to set up a situation that ends up getting messy because realistically, Mr. Goodman can't meet that goal.
To be very honest with Your Honor, and Mr. Good may not agree with me, I had hoped we'd have more money by now, but with the pandemic and his work schedule, he had not. And so he's talked about it with his fiance, and they've talked about, he's actually tried to do DoorDash and other things that'll bring in more money. And he feels confident that he can get this done in the 12 months. I personally, because I've been working in the system for 30 years now, I think that the ability to do it a little bit longer, maybe 18 months would really help him. But I talked to him and he's so confident because he wants to do this. But I don't know. I just, for me as a lawyer, it might be a little tough trying to get $1,000 out, but he just is so eager to do this. He tells me, Ms. Hornsby, yes, I'll do it. But, so whatever the court, I know you're probably wiser in seeing how many cases come back for no restitution being paid. I just don't, but that was just my opinion.
Okay, thank you for sharing that. Mr. Goodman.
Yes, sir.
What do you want to add to this?
Well, I do want to speak to the family, to Miss Moore and her family. Nothing can take back the day that changed everybody's lives. There's nothing I can do that I could bring that back and let it go a whole nother way. But the moment that it happened, I put my all in to make it better. The moment it happened, I'm the one that called the police. I'm the one that tried to cater to her till the police and ambulance came. I never ran. I never made any situation to not take ownership of what I've got of what I've did. And I'm very apologetic to the situation that we are at right now. But I am also thankful that your grace helped get this case done. And all I want to do is just get this done and help out as much as I can, although I can't change what have been done. But I can do my best to help and take responsibility and accountability for what I have done to your family. And I do apologize deeply for it.
Mr. Gooden, why do you think you can get $10,000 in 12 months?
Well, I work at a warehouse, and right now we're finna go into our peak season, and I have to do what I have to do to get this passed. So I have to put myself in a position where I have to work 6 days a week just so I can take care of my family and also do what I have to do and take accountability for it, because the only thing I can do is accept responsibility, and that means I have to do what I have to do. And so for the next 6 months alone, I'm going to work 6 days a week. And that'll going over the finances with my fiance, she's a finance major, so I'm pretty sure that together we can do it. I can't do it all alone, so I'm gonna need help, and I got the help that I need, I believe.
Okay, does your fiance work?
Yes.
What does she do?
She works at Fulton County Government Center.
Do you know what she does there?
Public works, I apologize.
Okay. All right. Well, Mr. Goodman, I find there is a factual basis for your plea. You were the driver, you were the one who fell asleep, and what happened after that is, as we've all agreed, something that poor Catherine's gonna carry with her the rest of her life. It sounds like she has fought mightily to heal and work through it, and with the help of family and the medical profession, she's doing better, but it's not the kind of thing that in the end is just gonna be, see this little scar here on my arm, but everything's okay. So this is real serious. But it also sounds like this was not one of those bad intent crimes. You were not trying to have this happen, Mr. Goodman. So while it will weigh on you, it does sound like you have tried to rebuild in the same way that Catherine is trying to move forward. So there's a factual basis for your plea. I find that your plea is knowing and voluntary. Knowing means you've understood all the things we talked about. Is that a fair statement?
Yes, I understand everything.
Okay. Voluntary means that while this is not necessarily a happy moment for anyone, you are here because you've decided the right thing for you to move forward is to accept responsibility, enter this guilty plea, and agree to pay the restitution. Is that true?
Yes, Your Honor.
All right, then I'm going to accept your plea. I will sentence you to 12 months on the first misdemeanor and 12 months on the second misdemeanor. I will probate those so that you are out and working and a productive member of society. A special condition of your probation is that you will pay $10,000 in restitution to Ms. Moore. You won't deliver that personally. You will deliver it to probation, and they'll get it to Ms. Moore and her family. And I'm going to establish a payment schedule so that if you fall behind, you and I have a meeting. Of course, Ms. Hornsby will accompany you to the meeting, but we'll talk about what's working and not working. You will need to have paid a minimum of $3,500 within 6 months. You need to pay an additional $3,500 within 12 months. So that's $7,000 in the first 12 months. You're welcome to be ahead of schedule. If you pay $5,000 in the first 6 months, hats off to you. But I'm going to be checking in to make sure you don't fall behind. And the final, the remainder is due within 18 months. So I'm giving you an extra 6 months to pay it. Not because I think you need it. You seem to have a plan in place, but life is complicated, and you have other folks depending on you as well. So I'm going to have those 6 month check-ins. First 6 months, you pay $3,500. Next 6 months, another $3,500. That leaves $3,000 for you to take care of in the final 6 months. Of course, you got 24 months probation, so I've always got room to work with if it seems like you are spending your money other than taking care of your obligations, in this case, your obligations to your family. I think that's how I'm going to structure it. Mr. Abate, did you have any conditions you wanted in terms of probation?
No, Your Honor, I would leave it in the discretion of the court.
All right. Ms. Hornsby, anything you want to add?
No, we were just trying to wonder how to work out with the pandemic Zoom kind of situation, how we sign up for probation and how we get this first little bit of money to them as soon as possible.
Right. So misdemeanor probation is not supervised, as you know, Ms. Hornsby, by the Department of Community Supervision. So we'll provide through you to Mr. Goodman what he needs to do to sign up for misdemeanor probation. And then they will have a location where he can bring money order. You don't bring a bag with a dollar sign on it that has $501 bills in it, Mr. Goodman. You're going to need to turn it into probably a cashier's check or something like that. But I don't know, don't take it from me. You will get the specifics from the folks at misdemeanor probation. But you'll need to sign up with them to figure out what the situation is. Ms. Crawford, do you have any insight as to how Mr. Goodman connects with misdemeanor probation, or will I talk to Ms. Nelson about that?
I think Ms. Nelson has that information.
Okay. Ms. Nelson, are you able to be heard on this call? I know you're working through some technical issues.
Yes, yes, Judge, I can hear you. I will probably be able to email Ms. Culpepper that information on the probation misdemeanor and that how they'll have who he will report to.
Okay, sounds good. So Mr. Gooden, the most important thing you're going to do in the next couple of days is plug in with probation. They need to get to know you, you need to get to know them, and they'll let you know how you get that first payment to them. And then they will forward it to Ms. Moore and her family. Mr. Abate, I guess we'll need to get, you can get this to Ms. Nelson, but the contact information so that payment can get to Ms. Moore and her family.
Yes, Judge.
Okay. All right. I think that covers everything. Your indictment, Mr. Goodman, to which you've entered the guilty plea, if you were here in court, you would sign it indicating you're pleading guilty, as would your lawyer and Mr. Abate. Do you authorize me, Mr. Goodman, to sign the indictment on your behalf?
Yes, Your Honor.
Ms. Hornsby?
Yes, Your Honor.
Mr. Abate?
Yes, Judge.
All right, I'll sign the indictment for each of you, and we'll see where this goes. I will flag just once more the possibility that the clerk's office has a hiccup with the final disposition because we have an indictment with 1 count and a final disposition with 2. And so there's no panic on anyone's part. If we're told by the clerk's office that they will not accept a 2-count plea, then I will be reaching out to Mr. Abate or Mr. Pinion to have an accusation drafted up that would apply to this scenario. I don't think we'll need to have this entire plea colloquy again, but we'll loop Ms. Hornsby in, and I can be any surprises. But I just want to prepare everyone for the fact that it could be procedurally, we need to go with a plan B, where it's an accusation alleging the 2 misdemeanors to which Mr. Goodman has already entered a plea, so that it goes through the clerk's docket.
Okay.
All right.
Mm-hmm.
Yes, sir.
Anything else for your client?
No, Your Honor, that's all, and that completes my business. May I be excused?
You may. Ms. Rolak, anything else from Ms. Smith or Ms. Moore's-Band?
That would be all, Judge. Thank you.
Well, thank you all for dialing in. Mr. Abate, we'll keep you posted. If you hear nothing, it means the paperwork went through. Otherwise, we may need to get an accusation. Okay?
Yes, Judge.
All right. Thank you, everyone.
Thank you, Judge.
Thank you.
All right. I think that is it for our morning calendar. We are back in session at 1:30 with no inmates. I think there'll be some people physically in court, meaning lawyers. I've got a meeting that's on Zoom that I'll do from right here, starting at 12:30. But you guys should feel free to lock your courtroom and go have lunch, take a break. Just please be back at 1:30, and we'll pick up with the calendar. All right, thanks. How did it go back there? Pretty smoothly?
We don't have a board. They had 4 next door.
Okay, yeah, I had forgotten, we're trying not to have courts up at the same time, but 1C is gonna be going every day as we try to work through some of those old prelims. Do you hear anything from the other 2 courtrooms? Did that go smoothly also? You wouldn't, but I guess if something real bad happens, you would have heard, so it's nothing real bad. All right, well, thank you both. Mr. Forte, I'll see you around 1:30. You're welcome to come and go as you need. We're having a case council. Yeah. No, because this is all status review. If we were taking a plea in someone's case, then we might need to take them. You don't need to take them personally. I'm not quite sure why this part was in person, other than they're in custody and we don't have a Zoom feed during drug court. And we do have a bus now, so that's why, but you don't normally take down drug court stuff, again, unless.
The board is going to do, check the judge, do it by Zoom, but wasn't sure.
We will have folks plugged in via Zoom for it, so you can. If you need the link, ask me for it.
I'll do it. I'll take my phone.
Okay.
What I like to do is set it at home.
Just in case.
I'll do it.
Good plan. Thank you. See ya. So I don't know what's gonna happen with this. One felony turning into two misdemeanors.
Do you know that you have a plea here?